All right, today we're talking about overcoming legal pitfalls in business, right? And how to navigate through legal issues that's common to most small businesses. And to help us address this, we have Peter Smith, one of the founders of Smith & Malek, and also one of my favorite people. So let me do a quick intro on Peter. He was born and raised in Sandpoint, worked as an attorney for Lukins Annis. In 2015, he and his good friend Luke Malek opened Smith & Malek. And his expertise is in business and real estate law. And he works with business owners to avoid business mistakes, protect their assets. He's married with 3 children, enjoys running, biking, skiing, and golfing. So Peter, welcome.
Thank you, Bill. I appreciate it. And do I get to see the list of people who are participating today, or do I just look at your screen, Bill?
So Peter, before we do that, anything else you want to add about you or Smith & Malek?
You know, I've been practicing law for 17 years in Coeur d'Alene, and what I'm going to talk to you today is going to be some high-level stuff that I see as challenges for small business owners. Some are stuff that was outside their realm of knowledge and they walked into a mess, but more often than not, it's something that they could have avoided with some simple planning. So I'm hoping that what we do today, based on my experience, is have a dialogue about these different issues that I see. And one of the keys here is I want to deliver value to you today. So hopefully if any of you have specific questions as we go along, or if you have an issue that has popped up you want to discuss, most of the time, the questions that you have are relevant to the other folks, or at least I can take that question and apply it more broadly to other folks who are also on this. So I'm happy to do that, and I hope I can deliver value that way. I do have content ready, and hopefully we can get through it. But if we start talking about things that you want to talk about, I think that's the most value that we can deliver.
Great.
So I really appreciate this opportunity, Bill. Thank you for your kind words, and I think it'll be a very helpful discussion and hopefully open some or provide some insight for folks that they didn't know before.
Thank you, Peter, and look forward to that. So just to prime the pump a little bit. So we just listed some stuff that you may be interested in or thinking about or struggling with: legal structure, partnership agreement, operating agreement, employment law, contracts, multi-state business issues, and so on. So Peter is, this webinar is for you, as he said, and so we want to address the questions that you have. But we can begin. We're gonna, if there isn't any, we just begin to talk about some issues until you give us some questions, and we have 1 hour, and so we want to use that to your benefit. So please. So a couple of ways to ask questions. One is raise a hand in case there's multiple people. And if there's no other hands up, you just go ahead and open your mic and ask away. Okay. And so I am going to stop sharing so we can see your faces. All right, there we go. And it will be helpful if you're going to ask a question, if we can see you. That'll be helpful for, I think, and because there may be maybe a dialogue back and forth. So, all right.
Thank you, Bill. It would be helpful for me if a couple of people or most people would just tell me briefly, very quickly, the company name they're with and their position. It really helps me frame the context of what we're talking about. So, starting with Andrew, would you mind just sharing your position in your company?
Yeah, so I'm a podiatrist. I'm actually in California right now, planning to start a practice in Idaho. And I have questions on employing staff. Never done it before, so that's really concerning to me. And then business format. And also I have questions around premises and lease agreements.
Thank you. And Anthony, are you on there? Can you mind sharing?
Yes. Let's see. So I'm just getting started as an entrepreneur. Started a couple LLCs, and so I don't really have much experience as far as business legal issues, but yeah, interested in hearing about operating agreements and how they relate to taxes.
Thank you. And Curtis, could you just tell us your position and your company? And we'll skip over Curtis and go to Deborah.
Deborah is a coach.
Hi,
Yeah.
I'm a coach.
Oh,
I'm a
perfect.
coach for the SBDC, so I work with business owners. Thank you.
You're welcome. Elizabeth?
You're
Jared?
on mute. Bottom left. Bottom left of your screen. Okay.
If Jared is on, position and company, that'd be just helpful for me.
Okay. So Elizabeth, there you
Okay,
go.
there I am.
Yeah.
Okay, yeah, I'm just starting out, and before I put up my both feet in and start buying equipment, I want to go through the seminars to see exactly what I'm getting into. So, especially the legal pitfalls. So I own a lot of land and stuff, and I don't want to get myself in a position where it could all be taken away.
Those are excellent points. Jared, position and company, just really quickly.
How do I do it?
Maybe Jerry. Is Jerry, are you willing to share?
Hi, I'm here. I'm with Jared too. We're with the same company. We're just we own an inspection company in Post Falls. And so we are signing on to learn everything we can.
Awesome. Jessica, just really quickly. There's two Jessicas, I think, so.
Hi, yeah. I am the owner and manager of Pine Creek RV Park and Campground.
Okay, I guess I'm Jessica. I own a small business that I used to sell my art. I do retail and wholesale, and I'm located up in Bonners Ferry, and I've been in business for about 2 years, and so I'm here to just make sure that I haven't set myself up to like fall into legal pitfalls, or that I have my bases covered.
Thank you. John?
John's a coach.
Oh, good. Sorry if I'm calling on coaches. Karen? Give
Hi.
Karen a sec. Hi.
Hi. So we're just starting a laser engraving business, and we're going to do mostly online sales. And a couple of the things that I've been hearing that other people have experienced is making sure that your website is ADA compliant. And I've heard that there are lawyers out there that kind of seek out websites that aren't in compliant and then try to sue you. So I would like to discuss how to prevent that and how to go about making sure the website is ADA compliant.
Great questions. Christy, really quick.
Oh, hi. I am actually looking to start an RV park, and so we're just kind of learning some of the legal pitfalls of doing so.
Sparrow?
Hi, so I'm Sparrow, and I'm branching out and doing this really cool idea that I discovered from Europe, and wanting to help parents without partners formulate a micro community where business and childcare and housing is all under one roof. So I'm looking at like what type of entities do low-income housing usually fall from, and anything else I can learn about contracts and partnership agreements.
Great. Timber? Well, that was the last one on the list. So thank you all for sharing. I really do appreciate that. It helps me in putting into context who the audience is so we can talk about things that are relevant to you. If all of you have been established businesses for 20 years, or some things I certainly wouldn't need to mention, but it sounds like to me you're all kind of in that starting out phase and you're thinking about how to get your business going and what the different options are for you. And so the first thing I'm going to talk about is your entity choice. When you're going forward, the first option you have is just to run your business as yourself. If you do that, you are exposed to all the liabilities of the business, including debts. If somebody gets injured at your business, if somebody sues you because you have a non-compliant website, all the personal assets that you own are exposed. That's your house, your car, your banking account, and everything else. So most folks, when they go to start a business, you've probably seen the commercials on TV from LegalZoom, they talk about corporations, LLCs, limited partnerships are the basic entities that you have. The benefit of those and what they help you avoid is personal liability. All the assets of the company are exposed to a claim, but not your personal assets. So when you put money into the company, so you put $10,000 into it, that's all exposed to whoever sues you, but nothing more than that. And we'll talk about a little bit about how you keep that protection in place, but that's the benefit of having an entity of some kind. And there's a lot of confusion, I think, when I hear from business owners telling me what type of entity they should have. A corporation provides the same protection as a limited liability company or LLC. The difference is a corporation has shares of stock, it has a board of directors, it has bylaws, it has officers. It's highly regulated in the fact that most states have a lot of codes that deal with how corporations are to be run. And then we get into the tax ramifications for corporations too. There's two different ways that corporations are taxed, and a lot of people refer to their corporations this way. I have corporation, I'm running a lawn care business and I'm an S Corp. They'll say that. That means one of two things. One, they're either a LLC, taxed as an S Corp, or they're a corporation, taxed as an S Corp. So when you're thinking about when you're forming a company, you have the choice of doing a corporation or a limited liability company. There's some benefits to each. The biggest benefit of a corporation is it's very structured. You have a lot of laws that govern what you can and cannot do. For example, for an S Corp, you can only have 100 shareholders. You have to pay out all your profits based on what you own. So if you own 50%, you get 50% of the profits. You can't change that. You can't say, oh, well, this quarter, I worked a little harder than my partner did, so I can take out 60%. In an S Corp, you can't do that. You have to pay out the profits by the percentage of ownership. One of the benefits of an S Corp, being taxed as an S Corp and being formed that way, is any distribution that you get. So you have wages, which are taxed just like W-2 income. So you pay employment tax, which is, if you're self-employed, a 15.6%, I believe, tax. And I'm not a tax expert, so I get my percentages a little bit wrong. But you get taxed on that, and you can pay yourself a minimum salary, and the rest of it is called distribution, which is taxed at a lower rate, the capital gains rate, so a dividend rate. So there's a benefit on the tax side of doing that. An LLC can be an S Corp, so everything we just talked about works exactly the same way, or it can be taxed as a partnership. It's confusing because an LLC is not a partnership, but it's taxed as a partnership. So people often come in and say, well, I have an LLC, but I'm not sure what it is. Is it an S Corp? Is it a partnership? Why do we have all these complicated rules? And I'm going to keep it very simple for you. As you're forming your entity, if you want to be a partnership, every dollar that comes out to you in profit is taxed at your income tax rate. So you have a slight benefit of being an S Corp if you want to take advantage of that. The benefit of the partnership is you can pay out the profits any way you want. So if you have 3 partners in a business and one of them works a little bit harder during the quarter, they can receive a higher percentage. You can agree on how you're going to do that. And I'll talk about how we form these entities and what governs them next. So those are your 3 options: corporation, LLC, and a limited partnership. And the limited partnership is just like an LLC. It's not very regulated. You draft an agreement on how you're going to manage the company and what you're going to do and what roles you're going to play and what money you're going to get. So how do you become an owner of one of these entities? In a corporation, you own stock. It will issue stock certificates. Most small businesses don't do that. You can go to or Staples and buy stock certificates, print them out and sign them and give them to shareholders, telling them how many shares of stock they own. Or you can just write it down in the ledger and say, I own 25%. Either way is just fine. In an LLC, you don't acquire stock, you acquire a percentage of ownership. It's called a membership interest. And then what that gives you is a percentage of the profits, or if the company sells everything, you get a percentage of whatever comes out of the company after it sells all of its assets. Most operating entities, so companies that are working on a daily basis, providing a service like a law firm or a dog sitting service, a lot of them will be formed as an S Corp because of the tax benefits that they get. And they may be an LLC. I would recommend for you, as you're starting a new business, that you strongly consider the LLC because it's a bit simpler to manage, and then have your accountant determine, do you want to be a partnership for tax or do you want to be an S Corp for tax? There's one other option you have, and that's a corporation that's a C Corp. Amazon is a C Corp. Large companies with many, many shareholders, because you'll remember S Corps can only have 100 shareholders, will be C Corps. So what that means is they're taxed on their profit, the entity is, and then everybody who receives a dividend from the company pays tax again. It's called the double taxation. In most of your cases, I would say you would never want to be a C Corp, and because there's no benefit to you. And most of you could be an S Corp because you're not going to have more than 100 shareholders. If you are an LLC, you can have as many owners as you want. There's no limitation whatsoever on that. So as you're going into forming these entities, you're going to want to think about what documents you need in place to protect yourself from the liability. Again, what we're trying to do here is form an entity that protects you as an individual from claims. And I'm going to speak just for a second about the 2 types of claims that exist. One is the slip and fall. It's the accident that happens at your business or is somehow related to your employees where you have liability. The best way to protect yourself from those claims is to have the entity be formed and buy insurance. Insurance covers accidents. Now, insurance doesn't cover if you were to take a baseball bat and walk out on the sidewalk and hit somebody. That's an intentional act, and I'm sorry, there's no liability protection from that, no matter what you form and what you do. The other liability is contracts. So if you sign an agreement, and this is where I see some business owners get a little sloppy. They sign a contract with a provider of a service. Say you're signing a contract, you're going to deliver a million widgets to me, and I'm going to resell them. Or I'm going to sign a lease for a space in my RV park with you. If you sign that as Peter Smith, I'm signing the lease, me individually. So if there's a breach of that contract and we go to court and there's attorney's fees awarded because I breached it, all the assets that I own are on the line. So my house, my car that I own, my bank accounts in my name are all exposed. If I sign the contract as ABC LLC, Peter Smith, manager or member, the company's on the line and only the company assets are exposed. So after you get your entity formed, you're trying to protect yourself from those liabilities. You want to make sure you sign contracts in the appropriate business name. And make sure the signature line that you sign identifies you not as an individual, but as whatever position you have in the company. And it'll be slightly different for corporations. You'll be the president, vice president, whatever title you want to have or give yourself, chief executive officer. Just be sure you sign those contracts with that designation, or else you could be exposing yourself to personal liability. And as lawyers, that's the most fun thing to do, because then I have leverage. If I can sue you and say, well, your house is on the line and not just your business, and I can get a bigger settlement out of you to make this thing go away. Let's talk about piercing the corporate veil for 1 minute. Good question. Karen Shaver asked, can you sign as an owner as a title? If you sign as owner, your organizational documents, whatever you have, your bylaws, should designate that as an official position. It's very unusual to have that be a designated position. If you sign as owner, I would make the argument you're signing as an individual, not on behalf of the company. So keep it the signature line as a title. The different titles that you'll have in corporations are presidents, vice presidents. In an LLC, you'll either be a member or a manager. And I'm going to get into when you bring your partners in and you find investors and how you structure that in a minute. We'll talk about the differences. Piercing the corporate veil. This is often talked about, very rarely successful. If you sign everything, a contract, or you operate your business properly, very, very low chance that anybody will ever get to your assets. The only time they'll get to you through the business is if you do something intentional. The baseball bat on the sidewalk, when you hit somebody, yeah, you're going to be personally liable for that. And every asset you own will likely be liable for that. However, if you're just operating your business and I'm the plaintiff's lawyer and I have a slip and fall and I say, well, this business only has $10,000 in its account, I want to go after the person because I know that Elizabeth, for example, has assets and she can pay me a lot more than the company can. I will try to pierce the corporate veil. The way you prevent that is two very simple ways. One, operate the business as a business, have its own checking account, make sure that it keeps its funds separate from your funds and distributes money to only you. The other way that you do that is make sure that you sign all those documents like I talked about before as the company, and that'll prevent them from piercing or going through to the entity. I want to talk just quickly about bringing on partners. If you were to bring on a partner, you got to think about a couple of things. One, what are they going to give you to be a part of the business? Are they going to invest in the company? How much money? Are they going to invest services? Are they going to invest assets, property, cars, equipment? And then after you determine that, what percentage do they get? Do they get 25%, 50%? And when you figure out the percentage, you say, okay, who controls this business? Does the majority shareholder always win? Is there a hybrid of where we have to have everyone agree to do something? For example, can the majority shareholder decide to sell everything and quit? Or does that require maybe you as a minority owner consent, so sign off on it? And in a corporation, you'll have a stockholder agreement, which is an agreement that lays these things out, how you're going to run the business, how you make decisions. And in a LLC, you'll have an operating agreement. These are all technical terms that lawyers know, but basically, if you want to just distill it down, it's just an agreement. Then we got to talk about getting out. Bill mentioned the value of your business as it grows. How do you get out? Or how do you get out if you have deadlock, if you and the other partner can't agree or maybe can't work together anymore? A couple of strategies you should consider. One is called a put call. If you and I are business partners and I'm not able to continue in the business or don't want to, I value the business in my own mind. I say, okay, it's worth $1 million and I own 50% of it. I go to you and I say, I'm willing to buy you out for $500,000 because you own 50% of a $1 million business. There's no appraisal. It's just a back of the napkin I figured out. You as the partner say, I could take the $500,000 or I can agree to buy you out for $500,000. So what does this do? it makes me make a fair offer, because if I offer you too much, you're going to take the money. If I offer you too little, you're going to buy me out. It avoids appraisals, it avoids lawsuits, it avoids a lot of time-consuming and costly ways to get out of a business. The only warning I have there is if you're the person with all the money, you may have an advantage over the person who does not. Because I can come to you and say, I've got the money, I'm going to offer to buy you out for 500,000. You have no way to buy me out because you can't match me. Other ways we value the business, do a, what's it called, an option. So we say we have somebody come in and value it, and I have the option to buy you out, or you have the option to buy me out at that price. And we can just, by a contract, agree that this is going to happen on this date. If I tell you I'm buying you out, I'm buying you out. Last is you try to find somebody to buy your business or your share of it. And then you come to me and you say, I've found this person to buy me out, and I'm going to offer them, they're offered me 500,000. You have the chance to buy it first. Problem with that is if you're the person in the business, you're stuck with a new partner in some cases. If you're the person trying to sell, it's very, very difficult to sell any percentage of a small business. The reason it is because most new owners want full control and they want 100% ownership. So it's difficult to figure out how to do that divorce. Most clients that I have like the idea of the put call, but then when they play it out, sometimes they say it's just not really worth it. As you go to get out of your business, you have to consider, okay, what happens if you get into a fight? What do? Do you sue each other? Which lawsuits in Idaho right now are running from start to finish about $150,000 for each side. And usually there's a contract provision that says you get your attorney's fees. So they're very expensive. You can go to arbitration, which is where somebody decides the case just like a judge. It can be quicker and a little less expensive. You can mediate, where you try to get somebody to help you settle. And in most cases, we try to avoid all of those scenarios by drafting a contract between you and your business partners to get you out. So that's kind of getting into the business together. I want to talk to you a minute about your employees. As you go and you hire employees, you need to consider a couple of things. First, Idaho and almost every other state is an at-work or at-will state. That means you can hire and fire anyone at any time for any reason. And this includes the employees that are exempt. So you pay them a salary and they don't track their hours, and non-exempt. Those are the ones you pay an hourly fee. And then there's independent contractors that you hire, and I'll talk about those in a second. So as you're looking to hire employees, you probably have heard about employment manuals and handbooks. And most small business owners say, I don't even know where to start when we look at an employee manual and handbook. And does it really protect me from anything? First, you don't have to have one. It's not required. It can be a good practice, depending on the nature of your business, to have one, so employees have clarity as to when they show up, what they do, and those things. But you've got to be careful you're not forming a contract with your employee with your handbook. So your handbook is basically just guidelines that you may follow, but the business owner, if it's drafted correctly, always has the right to deviate from it. What should be in your handbook? There are a multitude of things that you should have, and I'm just going to hit the ones that I think are most important. One, an anti-discrimination policy. You need to state that you as an employer and all your employees will not discriminate on race, sex, age, disability, genetics, religion. And that should be stated in the policy, because then if you get sued by an employee for one of those factors, you can point to your policy and say, our policy was that we don't do this. That's evidence that's helpful for you. The other is anti-retaliation. You should have a provision in your employment manual that says, I will not retaliate. If you come to me and you tell me as an employee, hey, someone sexually harassed me, my policy will say, I can't fire you for telling me that. And the reason that exists is because that's a great claim by a plaintiff lawyer on behalf of the employee to sue the business. And these lawsuits that come on discrimination, anti-retaliation, disability claims, they will bankrupt a business because the penalties are large. The cost of defense is large. And so you want to make sure you have a policy in place that trains your managers and employees how to avoid these situations. And this starts from the very beginning when you talk to an employee: hiring, firing, management. And it's never obvious. I've dealt with a lot of cases where people say, well, I was discriminated against because during the hiring process, I was asked where my parents immigrated from. Well, that question gives you an idea of their ethnicity, which could go to race. And it could be, in that case, weighed against another candidate, used as a claim to say, well, you only hired me because, or you didn't hire me because I was from this racial background. When you have employees, if you treat them differently, for example, if there's a nice office and a not so nice office, and you give the nice office to one employee and it's not based on any objective standard, the employee can claim, well, you've discriminated against me because I'm a woman, and you gave the man the office, or you gave it to that person because they're the similar religion that you are. Those are the things that you're trying to avoid with your anti-discrimination policy as you go through and develop an employment manual. Online, there are a wealth of resources, and I'm happy to give you some if you would like them, of what other clauses could be in an employment manual. But the big issue for business owners is just make sure you don't form a contract with your employee that they have a right to be employed by you. You'll have perhaps a process for disciplining, rewarding. Follow that if it's in your manual. And if you don't put it in a manual, just don't discriminate on the basis of a protected class. And you should be in the clear and not have future problems with employees. I want to talk about employment contracts and contracts in general really quick. You do not need an employment contract. The only employees that typically have employment contracts are highly compensated executives, high-level employees that are of a certain level in the business. And so there are a lot of people that come to me and say, do I need an employment contract for my receptionist? No, you don't. It's an at-will state. In fact, if you create an employment agreement, you may just cause yourself more problems inadvertently than what you need. So I would not, as a small business owner, be too stressed out by not having a detailed employment agreement for every single employee in your business. Now, obviously, with your high-level employees, you need to be concerned about their compensation. They're probably going to, if you hire an executive, going to ask you for some sort of severance if you fire them, some term to the contract. But other than that, I don't think employment agreements are necessarily that helpful for most employees. I would refer back to your employment manual, which are your guidelines to guide you on how you deal with those employees. Independent contractors fall into a unique category. And as a small business owner, you want to risk if you categorize people as independent contractors. And the penalties are significant. This is a claim that potentially could bankrupt a company. And that is that you told your employee, hey, look, I'll pay you X if you be an independent contractor. And the IRS and the state have put together a lot of guidelines, which are about as clear as mud as to when you're an independent contractor and when you're not. Here's the basic rule. And if you apply this, I think you should be safe in most cases. If you say how, what, and where this person works and what they do, they're an employee. If you give them a task, develop my website, and I want it done in 60 days. That's an independent contractor. They figure out how, when, what they're going to deliver. They determine their hours. But somebody who comes to an office every day, someone who has specific instructions on tasks they're supposed to follow, is an employee. So be careful when you're looking at independent contractors. They're tempting because from an employer standpoint, you save money. You save some tax dollars when you hire them, and you don't have to offer them health benefits, vacation, or any other of those benefits that you offer your employees. Benefits gets us into leave and termination of employees. So you have an employee, there's two types of leave. One is voluntary. That's where the employee says, I'm going on vacation. and you'll have a vacation policy. It says either it's paid or unpaid, how much they can take, when they have to tell you, under federal law, the Family Leave and Medical Care Act, you've got to be careful, FMLA, to be careful on if you qualify under that act that you're not violating it. But generally, voluntary leave is fairly straightforward. Involuntary leave is where you suspend the person with pay or without pay because of their conduct. This goes back to what I talked about earlier, the discrimination claims. This is where they arise. So-and-so isn't performing, and you decide to take action, and you say, I'm gonna put you on involuntary leave for a certain period of time. And the employee says, you're only doing this because of my religion, my race, my ethnicity, my genetic makeup, my sexual orientation, and they bring a claim against you. And so as you're doing involuntary leave, you got to make sure that you document why you're doing it, and it has to be an objectively reasonable standard. Termination is the same thing. When you go to terminate an employee, make sure you, as difficult as it is and time consuming, have documents in the file evidencing what they did, when they did it, and why it wasn't within your policy, your direction, or whatever you had that they were violating. Let me tell you, even the most sophisticated companies that I work with lack the documentation they need sometimes to defend a claim adequately. Why? Because it takes time. It's not fun to deliver a memo to an employee telling them if you show up late every single day, or you show up late 2 more times, or if you're on your phone at work, I'm gonna fire you. But that has to be delivered to protect you from the claim that you did it for some other unlawful reason. Keep in mind that during termination, my recommendation is you give no reason whatsoever as to why the termination occurred. The employee should know why they're being terminated when it happens. When they walk into that conference room, they will have received several memos, notes, however you want to deliver it, in writing as to why their behavior wasn't appropriate. At that point, they'll know, and you don't have to give a reason. And I would advise you not to give a reason. Simply state, this is your last day. You have 10 minutes to get your stuff. Thank you for your service, and end it. Any discussion you have there is going to be very likely used against you, or attempted to be used against you, or memories will be different. So that's what I advise on termination. On the topic list, we had a little bit about online businesses, and I noticed that a couple of you mentioned that we're in a brave new world on online business and advertising. Most of online business issues come from marketing and advertising and collection of data about potential leads and customers. California has put in place probably one of the most, it is the strictest law relating to online privacy and advertising in the country. In Idaho, we don't have that law. In Washington, they don't have that law yet. But because every online business touches every state and potentially every country, you need to comply with what those laws state. And I'm just going to hit these at a very high level. Number one, if you're advertising, it has to be truthful. If you make a claim, you have to have evidence to back it up. If you don't, you will be sued either by the Federal Trade Commission or the state equivalent, we have one in Idaho, or a customer. If you advertise truthfully and don't make outrageous claims and control what your influencers, if you hire them, the claims that they make sure that they're all within line of what your product can actually deliver or your service, in 95% of the cases, you will be just fine. There was a question about ADA compliant websites. Hire a decent web designer. Every web designer should know how to make your page compliant. There are people building their own websites still, and they are being phished. People look for these websites, plaintiffs' lawyers, and then they send you a letter for $25,000 and I'll go away. And you'll come to me and you'll say, what should I do? This is blackmail, because it may not even be true. You may just have you may have fixed the error, or maybe it really wasn't that big of a deal, or it didn't technically violate the law. But this plaintiff's lawyer says, I'm going to sue you. And I say, well, $25,000 is cheaper than the cost of defense, even if you win. And the plaintiff going after you doesn't have a lot of money, so they can never pay you back, even if you do win, if you could get an award of your costs back. So you're better off paying. My recommendation there isn't a legal one, it's a practical one. Hire a web designer that understands how to build your site, your mobile site, so it's compliant with these regulations. And they're not necessarily always in flux, but they are changing frequently. So be careful with that. The other area that business owners get in trouble is when they collect data about customers. California requires you to disclose everything about the information you're collecting, how you're going to use it, and give people an opt-out. There are a number of cases of people coming onto websites, giving information on the website, saying in their privacy policy, we use your data for X, and then they really don't do that. So if you have a privacy policy, make sure you follow it. You should always have a privacy policy so people know how you're collecting and how you're using the data on their websites. I think we all see it now. Every website we go to pretty much has that little cookie thing that pops up, says accept. And those are where the privacy policies are stated. If you ever dug into those, you'd see where lawyers have a lot of fun drafting, well, I can sell your data to Amazon, but I can't sell it to Facebook, or I can sell it to Facebook and Amazon, but I can't sell it to Google, or I can sell it to all of them. The other area you need to be careful on collection is of kids. Under 16 in California and under 13 federally is the magical age. If your site is attracting minors, those under 13 or 16, I'd be very careful in what you're collecting and how you're using it. The general rule is that parents have to consent, and it has to be an obvious consent in plain language as to how you're going to use data about kids. So if you're in that sphere, again, consult with a lawyer in online advertising that can help you. And also make sure your web designer is putting these tools in place to either delete the data, not collect the data, or be clear on how you're going to use that data. Again, those issues dealing with privacy, storage of information, protecting information of employees are the death of a company. If a claim is brought, it will be significant, it will be expensive, and in most cases, it will bankrupt the company. So just be aware of that. There are a lot of other areas in online advertising that get very nuanced. But again, I think if you protect the information and disclose how you're using it and avoid targeting kids under 13 or 16 and collecting their data, I think in most cases, none of us will run into any situation. Spamming of email it got a lot of talk. You just need to disclose in your emails that it's advertising, have a physical address, and allow people to opt out. That rule was reviewed in 2019, I believe, and is still in place. But most of the services we use today for online email marketing have those disclosures in them. So I'm less concerned now than I was when that first started. So I have covered almost everything. The only thing I wanted to hit, and then I want to answer some questions, if there are any, is litigation. Everybody fears litigation and says, what is litigation and what does it mean? And how much does it cost? And I gave you an estimate earlier. It varies because lawyers charge by the hour for litigation on a typical case. For most small businesses, it is a bet the company type of event. You get sued by an employee, you get sued by a customer, you get sued by another business, and in a lot of cases, it will use every resource you have to defend. So with that as your caveat, avoid litigation at all costs. You may get a blackmail letter from somebody at some point, consult with your lawyer. In many cases, the best business decision is to get rid of the case as quickly as possible. You can buy insurance to protect you. So I talked about before the two types of claims you have. One is a tort, an accident, the slip and fall. Your insurance company will hire a lawyer to defend you. in those cases, in most of the cases, as long as it's covered, and they will pay out a claim. What you want to make sure is you have enough insurance to cover you. $1 million will usually be spent pretty quickly, especially if the attorney's fees count toward the 1 million. You can sign up for prepaid legal services. Most of the policies I've seen don't cover any litigation. You can go in and talk to a lawyer for whatever fee it is per month. But I found that can be helpful if you use it on a regular basis, but often small business owners, it's so rare that they actually need legal advice on a regular basis like that, that just visiting with a lawyer periodically. I have clients who visit with me once a year just to go over the business, kind of get their arms around their legal needs, where they're at. And again, there's a lot of resources out there, and having a lawyer that you can call and talk to for 15 minutes, it may cost you $60, it may cost you $100. But the other side of that, if you don't get good advice, is hundreds of thousands of dollars. So hopefully you can avoid litigation by having good contracts in place and running your business and protecting yourself by forming the right entity. So I would love to hear if I missed something that you were curious about, so that we can get that question answered, so I used your time efficiently. Does anybody have a question?
Yeah, hi. I was trying to type it into the chat box there, but I figured it was just better asking. So is there anything specific to watch out for when entering into a contract to rent premises, commercial premises such as an office?
Yeah, number one, you got to look at whether or not you have to guarantee the lease. So, you sign the lease as your company, say ABC Corporation or ABC LLC.
Mm-hmm.
Are they requiring you to personally guarantee the rent? That's number one, because that exposes you, as opposed to just your company, to the debt. And you can, many tenants sign just as the company, and if the company doesn't work out, I mean, it's a bad deal, but at least your house and all your personal assets are on the line. That's number one. Number two is, well, on commercial leases, it depends on the sophistication of the landlord and the term. I always find that people are surprised by the cost of building out a space if they want it built out. So the economic decision is, what do I get for TIs and what's covered? If you're running an office, typically, just practical experience, they'll cover everything to build it out except for putting in your Wi-Fi and your data cables. And so then all of a sudden you get this bill to put that in, which was a surprise. There's indemnification clauses. So if you cause the landlord to get sued because you're in the building, you'll often have to defend the landlord, and depending on how broadly they write that, you can have exposure. But most of the commercial leases that I see are pretty fair both ways, and you just need to read through it and make sure you understand the terms and the economics make sense. You got to be able to pay the rent.
Okay. Yeah, thanks. And I did have a second question on hiring staff. It seems like, so if you have a staff member that's maybe not doing so well, it seems like you have to me, if you have to put everything in writing, like you're not doing this well and you're not doing that well, it's going to make somebody uncomfortable, and it seems like you're sort of getting on at them, rather than just kindly mentioning in their ear that they're not, can you do this way? Putting everything in writing seems like it would be like almost confrontational to me. But is that the way you're supposed to do it in case they end up being in a protected class?
Yes, the best is in writing, delivered to them after you have the conversation. So it shouldn't be a surprise when they see it in writing, right?
Okay.
The second best way is to tell them and then write a note and stick it in their employment file. You don't necessarily have to share that with them, but you can document the conversation. Today, I talked with Peter about him failing to dress appropriately again when he came to the office.
Uh-huh.
That kind of, you want the termination to not be a surprise. That's your goal.
Okay.
Because that avoids a claim, right?
Right.
So Don't let it build up inside you to the point where you blow up and then fire them, because then they say, well, I had no idea.
Right.
There's a question in the chat. The best legal structure for someone who wants to own and operate an LLC and take in investor money to pay back the investment or pay out a percentage of profits. So an LLC has an operating agreement, and you can set up your distribution of profits any way that you can agree to. So usually when you take on an investor, your company's already existing, right? You already have an operating agreement, and then they sign a new agreement, which we lawyers call a subscription agreement, that says you're going to put in $100,000, and when the company makes a profit, I'm going to pay you back the first, $10,000 of profits per month, or 10% of the total profits per month, or however this waterfall of profits goes, and that allows you to pay them back. When they're an investor, you got to keep in mind they own a piece of the company, and they're not a debt holder, so they get to vote, and you have duties to them under the operating agreement. And so you just got to keep that in mind, as well as how you're going to manage it, to what control do they have. But you can craft this with an LLC, Anthony, any way that you want, because you have unlimited flexibility. And basically it's what the two parties can agree to as to what they get back from their investment. Unlike an S Corp, where if they buy 50%, they get 50% of the profits. And there's those limitations that are built into that. So I prefer the flexibility of an LLC, though it can be time consuming to negotiate and draft those profit divisions. All right, so there's one other question here from Jessica. I'm considering hiring someone to do piecemeal work and independent contractor. Okay, so you want to avoid them falling as an employee. I go back to your test. Do you tell them how to do it, when to do it, and where to do it? Or are you giving them a broad task? Go create this for me, and come back when you're done, and you figure out the best way to do it and when you do it, and I'll pay you a fee for that. If this employee is only going to work for you and only do this person, and they're going to do it repeatedly, you're falling into the employee area. So be careful there. Idaho has, and I think Bill probably has, great resources on the factors that are used to look at whether or not a person is an independent contractor or employee. I can tell you that you can ask two lawyers and they will give you two different answers applying those factors, because they're not super clear. If there's a question, if you feel like you're controlling this person, telling them what to do, and they're going to work with you, and they don't do this for other people, not just you, but do it for other people, the same thing. If they're just doing it for you, I would default to the employee to protect yourself, because if you get into a wage and hour claim, there's huge fees if you don't pay overtime appropriately. There's penalties. There's not only that, but it's potentially bankrupting the company as well, especially when you're starting out. So I would look at those factors very carefully, and it's very, very fact driven. So there's no great answer of like, this is the way it works. Excellent questions. Well, I see it's 9:01, Bill. Thank you for the opportunity. Hopefully everybody got something out of this. I hope I addressed some of the questions you had in your minds. Bill has all my contact information. If there's any follow-up stuff that comes to your mind, I'm happy to talk to you and provide you any guidance.
Thank you, Peter. I'm going to put my slide back on and then put your contact info. Okay, and Peter, you covered quite a breadth in such a short time, and that was amazing. And I think you covered everything that I had written down. So we're willing to hang out just for a little bit if anybody else has additional questions. But thank you for joining us. And as I mentioned, we have many other webinars that are coming up. And those of you who are in business, who are starting a business, it's a lonely journey, because Peter and Luke in 2015 went through that same journey that many are going through. And it's helpful to have others who can give you some guidance who don't have a stake. And so you're welcome to leverage our coaches and leverage the workshops we have that really opens your mind to what is possible. So thank you for joining us, and have a great day. And again, we're going to hang out for a little bit for any last questions. Otherwise, we're done. Have a good day.
Thank you, everybody.
Yeah, thank you.
Well, Peter, I don't see any other questions. So,
Well, one pitch is you want to stay out of legal trouble as well is have a good business coach, because they will guide you through how to resolve disputes with each other if you have business partners, and avoid them altogether, because the fights between business owners are like divorces, and they are bet the company. And having a good business coach to say you need to communicate better or more clearly is very helpful. So that's my pitch for Bill and his team. They've been helping us for 6.5 years. Bill has. I can't put a value on it. It's not just profit, it's mental stability and well-being. So use them.
okay.
And Bill, somebody asked you where they find a business coach. I'm sure that they could contact you.
Thank you, Peter. Okay, well, all the best. All right, and you know where to contact us, nisbdc.com. Okay, have a great day.